Hello, my name is Emma Austin and I'm the Head of Health and Social Care Law at Central England Law Centre. This is the introduction to a series of webinars about changes to social care law for children during the pandemic. The remaining webinars cover specific groups of vulnerable children and changes that affect them, including disabled children, young carers, looked after children and children in care, and children who are in need, particularly those with no recourse to public funds. This webinar is designed for those working in the field of children's rights, youth workers, advocates, disability rights organisations, as well as for parent carers and carers. This webinar is a very simple overview to changes affecting the law for children. We won't go into details about the specifics relating to different classes of vulnerable children, as this content will be covered in the later webinars. We will, however, look at what can be done when there is a dispute about the support being provided to a vulnerable child or the lack of support being provided to a vulnerable child. By way of introduction, I think it's fair to say that families with children have been amongst those hardest hit by measures intended to curb transmission of the virus. Whilst there have been some measures designed to ease burdens on vulnerable children and families during the pandemic, the majority of measures that have been introduced are intended to ease the burden on local authorities and social services who might be called on to provide support and help to these families. And that means that some vulnerable children, many vulnerable children have lost out on support, have had support that they usually receive change or removed, and their families have been made, in some cases, more vulnerable as a result of the changes. There has been the introduction of new legislation and amendment to existing legislation, as well as the introduction of significant volumes of new guidance by the government. The Coronavirus Act of 2020 amends several existing pieces of legislation, including the Care Act, the Children and Families Act, the Chronically Sick and Disabled Persons Act, the Children Act of 1989 and the Education Act. Measures included in the Coronavirus Act affect disabled children, parent carers and also young carers, as well as measures affecting most children, i.e. school closures, but specifically children with special educational needs. There are also new regulations, the Special Education and Disability Coronavirus Amendment Regulations of 2020, which affect those with special educational needs, and they relate to education and healthcare plans in particular. An important set of regulations that have been introduced affecting children in care and looked after children are the Adoption and Children Coronavirus Amendment Regulations of 2020. And these regulations have the effect of making changes, of modifying and suspending certain duties set out in a number of other sets of regulations, perhaps most importantly the Care Planning, Placement and Case Review England regulations, but also a number of other sets of regulations which are listed there and which we'll go into in detail in the Children in Care and Looked After Children webinar. As well as changes to legal measures set out in the Act and regulations themselves, during the course of the pandemic, we've seen a lot of law introduced through guidance, which explains how public bodies, including the local authority social services and local education authorities, how they implement the measures intended to curb transmission of the virus, and intended to set out how support should be provided to vulnerable groups during the period of the pandemic. The most important pieces of guidance for our purposes are the guidance for children's social care services, the guidance for parents and carers supporting children and young people's mental health and well-being, the education, health and care needs assessment and plans guidance, which sets out changes relating to EHCPs and how those should operate. The temporary extension of free school meals to children from families with no recourse to public funds guidance, and guidance that has since been withdrawn but was very significant in shaping what's happened during the pandemic, which is the guidance on supporting vulnerable children and young people during the coronavirus outbreak, actions for educational providers and other partners. A key question those who work with vulnerable children and their families, or indeed the parents, carers of vulnerable children, might be asking is what can be done if there's a dispute about the support that's actually being provided or asked for, and what the local authority social services is putting in place or not putting in place during the period of the pandemic. Well, with the exception of certain decisions relating to provision of support to children with special educational needs, which can in some instances be appealable in the SEND tribunal, there are usually only two ways to challenge the decisions of councils regarding support to be provided to vulnerable children and their families. And those two mechanisms are the complaints procedure and judicial review. It might be that a child or their family need legal advice as to which of those two, if either, are appropriate to pursue in a certain set of circumstances. So if in doubt, please do refer your family to the law centre or to another legal advisor to access advice. And I would say an important caveat is that that often needs to be done very quickly, because the timescales to pursue, in particular, judicial review as a course of action are very, very tight. The complaints procedure, firstly, then, is a procedure that each local authority needs to have, and it has several stages. The first is that a complaint is made about support or services or lack of support or services received by an individual child to the local authority social services, and the local authority themselves need to internally investigate if there has been if something has gone wrong in their process, or if poor support has been provided. And local authorities should seek to resolve the complaint in the first instance themselves. If they can't do that and the child or family feel the need to progress the complaint, a complaint can then be progressed to the Ombudsman. The difficulty with the complaints procedure, it's always there to some extent, but at the moment perhaps even more so, is that timescales to actually pursue a complaint, for a complaint to be investigated and resolved, sometimes are a bar to actually resolving the issue at hand, because often immediate support might be needed, or a crisis situation might be unfolding that needs to be addressed very, very quickly. The complaints procedure isn't always the right way to resolve an issue, but it can be if there are, if there is time and a family are looking for an apology, or a kind of a different way for something to be done in the future, a new way of working, for example. The other mechanism is judicial review. And this is the process whereby the administrative court considers whether a public body, such as a council, such as a local authority social services, has acted lawfully. And that means acted in accordance with the specific rules set out in the law, in the legislation, the regulations, the guidance, etc., has acted rationally and has acted fairly. A judicial review does not consider whether, on balance, on merit, a local authority has made the right decision. A judicial review is simply concerned about whether what's happened is lawful or not. A judicial review has several stages, the first of which is that a lawyer on behalf of a vulnerable child or family will send a pre-action letter, a letter before claim, which sets out to a council or another public body why it's felt the council hasn't acted lawfully, how they failed in their duties towards an individual child or their family. At this stage, the council then has the opportunity to respond and hopefully address the points that have been raised and seek to to improve the family's situation. If that doesn't work, then a child or family is able to progress the judicial review claim, and that means to seek to have the claim issued at a court to be considered. At the first stage of the court process, a judge simply will consider whether a case might succeed or not, is capable of succeeding, and that's called the permission stage. If a judge considers that the case might succeed, that it is capable of succeeding, then the judge will grant permission for a full hearing to take place. If not, then the judicial review claim falls away at that stage. If the judge does give permission for the claim to proceed, then the claim is heard in a full hearing. Judicial reviews don't involve usually people giving evidence in person. It usually involves consideration of evidence that's already been gathered and arguments which have been set out by the lawyers in writing. The judge considers those, probes the barristers for the different parties who will explain or expand on points further, and then the judge will make a decision. Judicial review can be quite a slow process to get up and running. A claim has to be issued within, at the very latest, 3 months of the date a decision or action was taken that's complained of. So the claim needs to be issued very, very quickly. But it can take months for a case to then come to court and be considered. However, you can ask in a judicial review claim for a judge to provide interim relief, to grant an emergency remedy until the case is then decided. Alternatively, a case can be expedited if the circumstances require, which means that the claim can be considered very, very quickly. That means that where you've got a client, a child or a family who are in a very desperate situation and are really needing urgent support, if the pre-action process hasn't resolved the issue and a counsel hasn't engaged with the letter before claim or hasn't changed the way the family is being treated in response to that, then expedited hearing, seeking support, or emergency support, interim relief, can be quite a successful way of ensuring that the family isn't left vulnerable or isn't rendered in a more vulnerable situation by the time it can take for a claim to be heard. I hope you find the series of webinars useful. Please do get in touch with us if there's particular things that it would be helpful for your organisation to receive further public legal education about, or if you want to discuss particular issues or raise them with us, or of course if you've got individual children or families who need legal advice, do let us know. We are, during the pandemic, also running what we call COVID question clinics, which are for organisations, advocates, to essentially attend a Zoom drop-in duty clinic, whereby they can ask us questions about health and social care law, things affecting their clients, or if there's patterns or issues that they're seeing that they want a bit of guidance about or want to discuss with other advocates, organisations who might also be in the call. If you want to join these sessions, do get in touch with us and we'll pass you the details of the Zoom logins. We're also producing, as a law centre, an information pack which goes out on a weekly basis to organisations, and it sets out all the legal changes across social welfare legal areas, so not just limited to health and social care law, but also benefits, immigration, family law changes, housing law changes, etc. If it would be useful for you or your organisation to receive the info pack, do get in touch with us and we can add you to the distribution list. There is also information about services available in the Coventry area. Unfortunately, at the moment, that hasn't been expanded into the wider Midlands area, but we do hope to be able to provide more information about other services locally in due course. Thank you very much. My contact details, if you do want to get in touch with me, I'm best contacted on email at emma.austin@centralenglandlc.org.uk.